What's this crap? The summons. What is it? Well, I know what it is because it says a charge has been initiated by the council. Think about that. Who can initiate charges? The police and the CPS. When the can the council initiate the charge? Most people go into these. They have no idea what's going on. And they truly believe this is a due process of law. It's not. They've circumnavigated the rule of law. And you're in there on the belief that you're actually getting served justice. No, this is a private tribunal, just interpreting them correctly. We're defining the terms of what they mean. And we're having to do this for our public servants because they're following practices and customs and because they're fucking morons. Okay? Right. With regards to a dwelling, people struggle with this term. Okay. A dwelling house. Well, a dwelling house means a hereditament, yes? Which, in accordance with Schedule 13 to this Act, is used wholly for the purpose of private dwelling or private dwellings. Yeah? Okay. Right. Well, let's have a look. And there's some case law here. So she had the answer. She didn't even realize, right? So we understand a dwelling house means a hereditament. Okay. So, got some case law here. So, first of all, we have a look at the General Rate Act 1967, which explains a levy, the rate based on several acts dating back to 1874, with none of which provide a robust definition of a hereditament. In Walway versus Mazars 2015, which is UK Supreme Court, Lord Sumption stated the following paragraph: hereditament is a somewhat archaic conveyancing term, which is a matter of ordinary legal terminology. And this is important because you have to define the terms they're using. This is where statutory interpretation comes in. Okay? Which would descend upon instantly to the heirs at law. So, hold on, let's come further down because when you go through this, they then bring up the Law of Property Act with conveyance. And basically, what he's saying throughout it is it's no defined term, but I can bloody find the relevant bit. There hasn't been a single piece of legislation which adequately defines what a hereditary is. And it goes through, right, bear with me. Basically says that it's ambiguous, right? It's unclear in statutory definition. And then they come up with the fact that it's real property. So I'll put this over to you at some stage. Real property. Now, so basically, Lord Sumption goes through loads of paragraphs explaining that it's a very ambiguous term, that there's no true statutory definition. So what that means is without a clear definition within the statute, then you have to lean to any constitutional meaning. Okay. That's how statutes are interpreted for the rights of the individual and the constitutional interpretations. It's got to work with the constitutional law, which is top in the hierarchy of law. Constitutional law, statutory law. Yeah. Then the codes, the rules, the regulations, custom practices, etc., and then case law, common law. Okay, common law which is fused in. Common law's been codified and been blended into the statutes, which I proved with a Supreme Court ruling with regards to one of the family law cases I did. But basically, they define law assumption comes upon his own definitions. You've got the case law here supporting what you're saying, and he defines it because he goes through all these different forms of legislation. The Law of Property Act generates it, bum, 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 and says none of them clearly define what this term is. So a dwelling house is a hereditament. Okay, so we've gone from here to here. Okay, what's this? Well, Lord Sumption can't define it, so he then defines it. He can't define it through the statutes. Okay, because it's ambiguous in the Local Government Finance Act, the Generates Act, in the Law of Property Act. So he defines it as real property. Where have you heard that term? What is real property? I will tell you. It's real estate. What is real estate? It's commercial. There you go. That's it. I said, there's your answer. Just drill down on that point, and you've got the case law. It's all there. So what are they doing? They are committing civil and property rights violations. There you go. You've got the superior statutes, primary legislation supporting you. They've breached the rule of law. They've breached their duty, which is negligent. And you've got damages. Now, there's no remoteness. When you have to prove negligence, you can't have any remoteness. They have to have damaged you. Well, they have, because they've been taking money unlawfully and taxing your property rights. You have property rights. They are violating them. What are you going to do about it? You have to sue them. Right? So you've got the primary legislation, the breach of the rule of law, breach of duty, civil rights and property rights violations. You don't meet any of the statutory definition of a taxpayer, right? You are not exercising business privileges at your private property. You have no business license, no business registration, right? You are not involved in duty, customs, impost, excise. You can prove you are not filing tax returns. How hard is this? Okay, that's it.
It's not hard. It just takes time to it just takes the time, however long it takes you to dig into this stuff and learn it. It is really that simple.
People have to get their head around this, that you are that act, that statute has been misapplied to your property. Been misapplied. And you have to show them how. And you've got Lord Sumption explaining dwelling house, hereditament. So a dwelling house equals hereditament. Hereditament equals real property. Real property is real estate equals commerce. Lord Sumption's backing you. Got the case law there.
Yep.
Yeah.
Absolute
No.
facts.
There we go. So this is why you have to learn the CPR. Now, if we head back to, hopefully we're not jumping around too much. Just to give them another idea, just on statute.
Yep.
With regards to a case, because really we could go through this whole utility case from start to finish. I mean, that defense and counterclaim, that is a whole session in one go. We can go through the telecommunications quickly, and what I'm doing with helping another family that basically, and this also dovetails into the council tax, because they're doing the same thing with the school fines. Right. I've just put together a 7-page letter for action, a tort letter to both the court manager at a Roman magistrate's court and the council that are in cahoots with that particular court. Because what they've done, they violated his constitutionally secured natural rights. Okay. And they've defined him as a creature of statute. Okay. And been unable to answer any of the questions that were put to them or provide the information in the FOIA. Now, remember that when you send the freedom of information request, they have to keep within the four corners of what you've asked. Anything outside of that is an admission of guilt, or they just can't provide what you've asked for, which means why the hell are they doing what they're doing then? They've got to verify. They've got to be able to provide, this allows us to do this. Okay. Well, I've now looked at that and that doesn't provide the authority because you've misapplied it. You've misinterpreted it. Yeah. You've got to remember these people are morons, you know,
The
and the solicitors do not follow, but they're not following the legislation. And if they are, they can't interpret it correctly and they're misapplying. What they are actually doing is following previous customs and practices. That's it.
That's kind of like, it's a really interesting point because your default's always got to be that it's kind of what you can already make the assumption that they are either misapplying the legislation or they're breaching so many different procedure rules. That's your starting point. That's why Damian's saying get your head around that stuff. Because if you know what they're meant to be doing, 99% of the time they're not doing it. And so even the solicitors in a lot of these cases, I look at them as a weak link. If you can get rid of them, then there's no case. You know. Do you want to talk about that a little bit, maybe? Where
Yeah, you can always get them on a technicality, and this will also lead into interpretation because what we did there, what they've done, he ignored to basically his crime was taking just his property, which is his daughter, and she is his property till the age of majority. Okay, that's adulthood defined in law, uh, and took her on holidays during term time. Now, if you remember on the first one I did, they tried that shit with me, but I shut them down immediately. Um, but what he did was ignore the two fines, which we've now got as exhibits. We've got three lots of exhibits. That's the beauty. You turn the tables on. So now they've come at him with the Education Act 1996 using sections 4441 and 8. Now, 1A is nefarious because they try and then make it a criminal matter. But what these fucking idiots don't realize is there is a section that you can use within that very act, which is second on the law tier, because constitutional law is the top. And the statutory cannot contradict constitution. Okay. But this is why they took the British Constitution out of the law schools and the education system in the 70s. They did this for a reason. You'll have to excuse me. I want to find, so I've got all the paperwork here with regards to his particular case. So what I did, I crafted an S4 action. And I've said to him, look, be prepared to litigate this. This is what we'll do. Here it is. Where I've outlined the facts. And I've basically, look, what I've explained is first and foremost, outlined the facts with regards to the illegal issuance of a fine, brackets PCM, which is Exhibit A. Okay. That was received the subsequent malicious communications from, and I've named the party that sent it from the empty building, the two-dimensional legal construct, right? Because I'm after him. He sent it. We go after you in your official and your individual capacity. The official is his indemnity insurance. Okay, that's for public servant malpractice. That's if you're suing them in their official capacity. The individual capacity is where we go after his house, his pension, his car, and we leave the under the bridge with the other homeless, right where he belongs. Okay, excuse my language, but that's what these people are, because they're following practices and customs, right? I can't take your house, right? How the hell can they do that? Government and these public servants, the jobs they were instituted to protect our rights and our property. They're now doing the opposite. People have to realize that is wrong. Okay? Right. So I've outlined the fact that immediately the first thing they're doing is contravening primary legislation, which is the Bill of Rights, which is civil and criminal. Okay. They won't provide you evidence otherwise. But Gavin, you've got to understand, say to people, forget what they say because they don't know what they're saying. They can't interpret the statute. They,
It's a good
right?
point. It's not about what they, because a lot of people kind of they think they feel good about their starting point. They know their facts of law, and then they'll come back with some bullshit response. And it often floors people because, oh, this sounds legitimate. They seem like they know what they're talking about. But the point is, it's like Damian said, it's not about what they say. It's about what you know, and you got to stick to your
Yes.
guns because they're going to never admit liability, and they're going to attempt to deflect you. But if you know your starting point is right, you know your facts, and you know what you know, then you know what you know, and you keep going.
I've put together, I've sent them 7 pages that my 9-year-old could read this talk letter and understand what's being said. Okay. And the reason we do this is the same thing as you'll see in the CPR books. You know, you do a letter before claim or a letter before action. This is what this is: notice, letter before action. It's tort letter, where I put in the matter of tort, civil, and criminal offences relating to penalty notice. And then what they're doing. You know, I've explained the facts. Then I put is a fact in law, this counsel and the named respondents are not a court of law and have not followed due process of law, and that there are no provisions enacted within the Education Act 1996 allowing the respondents to circumnavigate or contravene primary legislation, i.e., the Bill of Rights, 1688. Therefore, if you continue in your illegal actions, um, coercing me under duress to appear at an administrative court over an illegally issued fine, after explaining the law in this tort letter, you'll be guilty of misfeasance. Then I've defined misfeasance. Then I've shown them the English legal system of jurisprudence has 4 classifications of primary authorities of law. So I've laid that out, the hierarchy of law: constitutional, statutory, administrative, and common, aka case law. Then this has also gone to the court manager because I rang the court and I found out who the court manager are. So I'm holding her personally liable. So I've got them both: the idiot at the council and the moron at the court. All right, these two been sent a copy. It is, and I've explained to the magistrate's court, it is a fact in law that no civil or criminal complaint has been filed with the court. So what are you doing? What's this crap? The summons. What is it? Well, I know what it is because it says a charge has been initiated by the council. Think about that. Who can initiate charges? The police and the CPS. When the can the council initiate the charge? They can't, guys. And this is done because the public, 99%, are ignorant. They know that you have no earthly idea how to call out the fraud, but I have throughout this letter. I've said, look, this summons, what is this? This is not a criminal, this is not a civil or a criminal complaint. What is this? And how can the council initiate a charge? And your rule, you're going under section 444, or section 7 of the same act. So I put particulars of charge initiated. Respondents are moving under sections 4441 and 8. And I've pointed out tier 2 of the hierarchy of law, reference above. And I've been dismissive with them. It is not necessary at this time to pay attention to those sections and disseminate them using the rules of language, statutory interpretation, and canons of statutory construction, because section 7 of the same Education Act contradicts those sections. Understanding that the aforementioned hierarchy of law, the statutory cannot contradict the Constitution, namely the Bill of Rights and my fundamental natural rights protected in the Bill of Rights, Coronation Oath Act, and the Act of Settlement. Okay? So this includes my civil rights, liberties, and properties. In this case, my offspring, his daughter, Nate. So we then define section 7 of the Education Act states it shall be the duty of the parent of every child of compulsory school age to cause him to receive efficient full-time education suitable to his age, ability, and aptitude, and to any special educational needs he may have. This is the important bit: either by regular attendance at school or otherwise. This is where we come into the canons. This is a disjunctive canon. Okay. This is a rule of language. So I've explained. So even if we come down at constitutionally secured rights, we're now going to come down to tier two, statutory. In this same act, the response to moving under it clearly states that every child, I've defined a child as a creature of statute, which it is, be educated regularly at school or otherwise, using the rules of language within statutory interpretation. We know that or is disjunctive, which means that in this case, it is the relation of two distinct alternatives. Or means in a statute, it's either this or it's that. At school, okay, so the statute is commanding we've got to have the creature of statute at school or otherwise. So here or here. That's simple. That's the rules of language, disjunction. Okay, and in statutes, you'll see and, which is conjunction. So it's going to be this and this and this. It's got to be all three of those things. But in this case, disjunctive, it's that or that in this case. So in simple terms, the statute is commanding that a creature of statute, parent or child, created by the legislature with only statutory rights, not superior natural constitutionally secured rights, tier two, not tier one. Yeah, you got to lay it out for them because this might have to go in front of an adult in the room called the judge, right? Who understands what I'm telling him, and he knows he's got somebody who understands the law and how to read it. Yes, this is saying do one thing or the other. So if a creature of statute has to be at school or otherwise, then I need to define otherwise. Okay, this is how you do it. You break it down for these fucking morons. Okay. The morons being the public servants. Otherwise defined means as differently or in another way. This means that while education is compulsory, you're like this, schooling is not. Parents, creature of statute, must make sure their children, creature of statute, get a suitable education either at school or at home, and in this case, while on holiday, wherever they choose. Now, how can they argue with that? They can't. So I go into the references with regards to suggested read A.V. Dicey, the law of the Constitution. Then I've explained that the magistrates court has circumnavigated the rule of law. So they are now, as per A.V. Dicey, the rule of law, they have breached the rule of law. Okay, which is a breach of duty. Duty plus breach plus damages equals a cause of action. You've got to have a cause of action to litigate a lawsuit, to have stand, to sue, to have standing to sue, locus standi, the right to sue. Okay, duty, perhaps they are duty. The council, yes, they do. They have a duty to the population they serve. When you take money from the public purse, you are liable. They have a duty of care to you. If they breach that duty plus breach and caused you damages, it's a cause of action. Okay, I've outlined that to them. Then I did a table of legislation, all the criminal acts, and there's loads of them. I won't go through all of those. Well, I'll just very quickly, I'll just say, look, they contravened the Theft Act, 1968, Criminal Law Act, 1977, the Serious Crime Act, 2007, the Fraud Act, 2006, and the Human Rights Act, governing acts of public authorities, Section 6, Human Rights Act, 1998. Is that? Yeah, 1998. So after the civil, we can then file a criminal complaint against them. So then I've done the subject matter where I've put it is a fact in law unless evidence be provided to the contrary that when I registered my daughter, my property until the age of majority, I did not agree to waive my God-given natural rights protected in primary legislation in exchange for statutory rights under the legislature created title of parent, which is a creature of statute. Done the same for the child. I've also said that I did not agree to grant the school, the council, and the state power of attorney over my daughter, and that I have not agreed to be bound by the terms and conditions of the Education Act 1996. This is where the contract comes in. Yeah? Simple stuff, guys. Right. Then cited presumption against waiver of sovereign immunity. We have to be individual sovereigns. A statute does not waive sovereign immunity. Source, Canons of Construction, Scalia and Garner. And I suggest that all of you, and I will give Gavin the link because the book's really expensive, get Scalia and Garner, The Interpretation of Legal Text. Outlines everything that I say. Okay? And it's what they go to. So I then laid out the two causes of action. One was a negligent infliction of emotional stress. The other was common law conspiracy, which basically outlines to both the court manager and this individual counsel that they continue that they're they're on very, very thin ice with regards to a common law conspiracy. These are two causes of action. And basically given it 14 days. Look, guys, you've only got to read this. We've laid it out, every facet of what you're doing. We've called out the fraud and we've shown we know how to do this and we're going to do this. You've got 14 days. And that's where we're at. The mindset is we're giving them the opportunity. Pull this nonsense out of the court because what they're doing, it's the same thing with the council tax where they initiate a charge and they pull you in front of a hired room within a public sport venue. And basically, it's no different. You're going into, it's like going into McDonald's, but you're not a McDonald's employee, but you're being dragged over the coals because you've breached some of their rules and regulations. That's what this is. That's what they're doing. And when you just go back to the root cause, hang on, how can the council initiate a charge? And the statute that you're using has been misapplied and you're contravening constitutional law. You've just got to go through everything. And now you're in cahoots with this individual here, because you've got to understand most people go into these. They have no idea what's going on. And they truly believe this is a due process of law. It's not. They're circumnavigating that. And it's no different to going into McDonald's as a non-employee. It's a private tribunal that's going on in a hired venue within a public courthouse building. They've circumnavigated the rule of law. And you're in there on the belief that you're actually getting served justice. No, this is a private tribunal. It's a private proceeding. So you only have to ask, I would say, don't go. And then the following day, ask for a certified copy of the case file. They have to do that by law. Right. And they'll never be able to provide it. So there's another exhibit, it's evidence. They'll send you some shit and you'll say, well, hang on, this isn't a certified case file. Right. So that's the last thing that I needed from you. I've got this hooky charge, this hooky summons, and now not what I've asked. And I'm now going to sue you. I'm going to file a civil rights violation, property violation, and then after that, I'm going to file a criminal complaint against you two people, not the court, not the council, you two.
Do you know what? The great thing about us doing what we're doing here is that because it's so fucking corrupt, because they breach so many rules. You just mentioned like the certified record. We get that commonly, and they never certify it because they can't because of the liability. And it's like what they're doing is they're literally handing you the evidence you need to go back and whack them on the head with.
Guys, Gavin, you've just said the silver bullet. So glaringly obvious. It's like that hidden in plain sight. These morons are brilliant at recording their crimes. They give you the evidence. That's how moronic they are. Yes?
It's absolutely true. So when you know what they're doing, if you know how it's meant to be, and you know what they're doing when they do it, the summons, all that kind of stuff, it's evidence. Let them do the stuff they're doing, and then you go and deal with it after the event. Like, don't go to court. Don't waste your time in that situation. Let them do what they do. Then go get your evidence and go whack them on the head with it.
What has it been proved time and time again? People turn up and they this, that, and the other, right? And they just get steamrolled. And it's a block, stamp bomb. They do 100 or 800 or whatever. That's not even due process of law. It's The whole thing is absolute fraud. But the fact that you've turned up, you're going along with it, you're part of the theatre, the pantomime. You've got no earthly reason to be there. You're notified. Look, this is what you're doing. This is what I've done. I've notified the court manager and I've notified the cat. Look, this is what you're doing. I've laid it out on a platform, a table of index, like any solicitor would. So you stop now. You've got 14 days to pull this, and we're going to put it down as a matter of practice and custom that you don't know what you're doing. But now I've outlined it, and if you don't, we're going to sue you in 14 days. That's it.
And just on that point there, just as a mindset change, one of the things I say to a lot of folks is that this is almost this default position that you're in a defensive position because they're the ones bringing this claim against you. And that's the mistake. You're not in a defensive position. Your starting position is you already know the whole thing's bullshit. So your starting position is one of, I'm just attacking. You're using what they're doing against them. Like Damian says, you turn the whole thing back on them. So it's a mindset mistake to be in a defensive stance against them because it's already starting from a position of corruption. They're never going to acknowledge anything you do. And that's where you kind of feel like you're losing and you're getting misdirected. Oh, what am I doing? Because they're throwing everything at you. But the point is, as Damien said, if you understand your rights protected by the constitutional statutes, you understand how to apply them, you bring it into tort law, which is your mechanism to sue, get your breach of duty, get your cause of action, and you're firmly on the attack. And normally, if you've got that all in your document, in your notice, in your letter before action, sorry, all the facts expressed, and you give them an exit, that's the key thing. So you're outlining the severity of the problem that they are in and their liability, but you're giving them an exit, which, forget about it kind of thing. You go away, I go away, simplifying that. Then you've done it. There's no more problem. So keep it really simple. Don't waste your time going around in these loops, rebutting everything that they're doing because you're in a defensive position, expecting them to admit their wrongdoing. It won't happen. Sorry, Dave, I just wanted to clarify that. So
No, you're right.
change your perspective.
They're not going to they're not going to express in writing. Oh, yes, yeah, yeah, we're in the wrong. I mean, they're liable.
That's why people feel like they're losing all the time with this stuff because you're always on this back foot of defending against them and they're ignoring everything that you're doing, even though you know what you're expressing is correct.
It's
So
like it's like catching a small kid with his hand in the cookie jar. Hey, I told you, no more cookies. What? I'm not doing anything. You've caught them. They're not going to admit to it. They can't. Oh, yes, yeah, yeah, yeah. We're in the wrong here. Uh, you're liable. You are taking anybody taking money from the public purse is liable. And this is where I was going to come into statutory definitions with regards to its understanding when to use statutory and when not. With regards to, for example, the statutory definition of a parent. Now, I've explained how that's a creature of statute. Now, with my son, and we're going to do a section, we'll do a 2-hour expose on how to move the family courts. I've, in 1 month, successfully defended his ability to action and create a child arrangements order with the opposing party's solicitor doing everything, including employing dirty tricks to stop that child arrangements order and stop his right of access to his child. We successfully defended that. Everything they said thrown out, everything they tried to put on record was thrown out, and we're steaming from point A to point B. It's going to be finalised in the new year, and happy days. So that was done, and the other one was stopping a non-molestation order, which is being weaponised. I'll go into that another time. It's basically saying where one party is saying, "Oh, the other's harassing me. Now they've got to stay away from me." That order is granted most of the time without following due process of law, and you can always hit them in a technicality because they don't follow process, and you can get that successfully defended, stopped, or thrown out of court, which we also did. So I'll go into that because a lot of people are affected with family law and the family courts. But if you know how to work them and the 2 acts that you need to know and the family procedure rules, you always get, I had 2 successes in 1 month. 2 cases, 2 successes. Okay? It can be done. right? So that we'll do another time, but I'm just going to go through this because this is relevant to Matey's case, and it also leads into the Interpretation Act. Now, the statutory definition of a parent, because my son in his specific family law case was using a statutory instrument. He was using a statutory process, i.e., he was putting a child arrangements order to the court to get the court to then agree to that, so that that would then give him the ability. Once that order was granted, he could then see his child. Yes, because the child was being weaponized by a wayward ex-partner. The usual deal. I shan't get into the semantics. So that's where you use your statutory rights as a parent, because we had to go with that because he had created a statutory order, child arrangements order. So, but then I used case law, I used legislation, to get this through, and I managed to negate and prove that a previous NMO was unlawful. I'll go into this more time at another time. But anyway, the statutory definition of a parent. See, in this case, we're saying, well, no, he doesn't meet the statutory definition of a parent. In the family law case, right, we used his statutory rights as a parent. In this case, we've gone above that to his natural rights. Yeah. Do you see the separation? So I've used constitutional law with regards to the school fine and pulled out, well, constitutional law that even and I showed how within that statute, even in statutory rights, they couldn't do what they were doing. But we went above that to tier one, so it's constitutionally secured rights, his natural rights. So the statutory definition of a parent, and this is where the rules of interpretation come in again, Gary. All right. The definition of a parent, this is from the Children Act, 1989, section 3(1). And there's case law for this, Lady Howe Supreme Court 2019. The definition of a parent, you ready for this? Includes. So I'm going to stop. The definition of a parent includes. What's the big word there? What have I finished on? I'll say it again. Includes. What is that? Right. So I'll tell you this again. This is where the common law comes in. You common law nutters. Look, you'll love this. The common law nuts that don't know the common law. Right. What that includes is the canon expressio unius est exclusio alteris. What is that, you ask? Well, pray I may tell you. This is the common law principle for construing legislation that, as interpreted presumption, may be made that an express reference to one matter excludes other matters. So that common law principle, what that is saying includes is this definition, but it excludes everything else. You'll see and, or, and include in so many statutes, and they read differently. They interpret differently to how you were taught at school. I've just given you a breakdown on one word there, includes, in legislation. Okay. It's the canon expressio unius est exclusio alteris. This is the common law principle that when reference is made to one matter, it excludes all other matters. So, okay. So knowing that, we can now read this properly. The definition of a parent includes. So it's going to exclude everything else. Any person. Oh, where have we heard that before? Right. Person. So it includes any person. Right. Well, don't we need to define person? Right. So guess what, guys? I'm going to do that for you. Oh dear, where is it? Here's what I prepared earlier. Here it is. the Interpretation Act, 1978, right? Where it clearly says person, quotation mark. That means it's a word of art. Okay? Includes. Oh, there it is. It's that word again. Includes a body of persons, corporate or unincorporate. I rest my case.
I rest my case.
So, person can only be a business, a company, or a commercial term, for fuck's sake. So, can I do this any simpler?
That is the killer piece, really, the person bit, because it's through all the legislation, all the statute. It's always there, that word.
So, we have just destroyed the creature of statute, right? The definition of a parent includes any person having all the rights, duties, power, and responsibilities and authority. Well, that's not a natural man or a woman. It's a creature of statute created by the legislator. And we've proved, again, it's a commercial term, it's a business or a company with their own fucking statutes, just interpreting them correctly. There we go. So that's how we were able to pull his natural rights away from his statutory rights, because we're clearly defining, we're not at the point of guessing, guys, anymore. Okay, we're doing this for real. We're defining the terms of what they mean. And we're having to do this for our public servants because they're following practices and customs and because they're fucking morons. Okay? I don't know.
Oh, you
don't
did
know if
crack
we
me
can
up, mate.
use
I love it.
I don't know if you want to end it there or we have a quick word on the 5G.
I think, you know what? Let's end it there, because there's a lot to take in, a lot to sort of disseminate. What we're going to do, guys, on the following up videos is, as Damian said, we're going to focus purely on some topics, because these are big topics and there's a lot of people out there struggling with the same thing. So the first is the family law stuff. We'll go through the cases that Damian's had and basically how to deal with them. Then we're going to go through that water utilities one, which the great thing about that is that the facts that Damian's expressed there are as applicable to other utility problems. So it's not just a water thing. You can use this for all of the other things. And actually even dovetails back into council tax if you want to take it that far. So we'll draw the curtains back on that and go through that. And then I think another video just around Telecommunications Act and these 5G towers they're either putting up or have put up, and how you can basically get that done. And just a quick one on that. Damian's at a point where I think not he believes, that's the wrong word. He knows he's going to have a situation where the council he's doing this with is going to have to take them all down.
Right. Not one, all of them.
All of them down. Yeah.
Because they're going to end up with a civil lawsuit from me for a breach of duty of care. They're going to end up with a huge fine from the HSE as per the legislation that they're bound by. And then both myself and I can get the HSE involved with a criminal complaint against those parties.
And just to wrap that up on that note, and I think this is the perfect way to end it, just that alone just shows you one man with some knowledge doing that stuff has the ability and the power, and this is the key thing, to shut all of that down in one council. Imagine what we could all do if we were all doing this stuff across this nation. Imagine the stuff that we could shut down. We all very clearly see the agenda that they're rolling out, but what we're trying to get across here, guys, is that it doesn't bloody matter. If we know what we need to know, we stop the whole bloody thing. Everybody's liable because everybody's equal under the law. And I think on that point, Damian, thanks again, mate. Really good interview, really good information. We'll see you on the next one.
Pleasure. Love and light to you all.
Do you find the legal system overwhelming and wish you had the knowledge and skill sets to control judges, persuade attorneys, and win your case? Well, look no further. Sovereign Empowerment is proud to announce our partnership with Dr. Frederick Graves so that we can bring you the Jurisdictionary Law course, How to Win in Court, your ultimate resource for mastering the courtroom. Unlock powerful case-winning strategies as you learn to control judges like never before. This comprehensive course eliminates guesswork and empowers you to navigate the legal landscape with absolute confidence. With step-by-step instructions, flowcharts, and outlines, you'll have all the tools you need to persuade and control judges in any case or court. Learn from a seasoned attorney with over 40 years of winning experience, who has distilled his expertise into this comprehensive program. Access everything you need in one single package, including sample forms, video seminars, audio clips, and in-depth case-winning classes. Learn at your own pace, anytime, anywhere. Our 24/7 online access allows you to tailor your learning experience to fit your schedule. Access the course on your smartphone, tablet, or computer and become a legal master whenever and wherever you want. Benefit from a suite of powerful tools, including a free online legal research tool, a legal dictionary with common sense definitions, and an exclusive Q&A forum to connect with fellow students and obtain expert guidance. Good people have suffered too long at the hands of power because they just didn't know how to fight back. Now, in a matter of just a few days, you can acquire the tools and knowledge that takes law students years to achieve. Can't afford a lawyer? No problem. With the Jurisdictionary Law course, you'll gain the skills to win your case without expensive legal representation. Alternatively, equip your own legal consult with the tools and tactics to fight effectively on your behalf. Level the playing field and secure your victory. No matter what court, civil or criminal, conquer any courtroom challenge with ease. This step-by-step guidance ensures a quick and straightforward learning experience, empowering you to navigate the legal system with bulletproof confidence. As a testament to your newfound legal expertise, you'll have the opportunity to complete a final exam and receive an honorary law degree upon successful completion of the course. Showcase your achievement and establish yourself as a force to be reckoned with in the legal arena. Dr. Graves believes everyone deserves access to legal knowledge. That's why we offer the Jurisdictionary Law course at an unbeatable price. For less than the cost of a 1-hour legal consultation, you'll gain unlimited access to this complete program for up to 2 full years. Take control of your legal battles without breaking the bank. How to Win in Court has become the most trusted law course worldwide since 1997. Don't miss out on this exclusive opportunity to gain the upper hand in the courtroom. Enroll in the official Jurisdictionary Law course today and unleash your legal power. Click the link in the description below to become legally empowered today.